Got a question on TikTok about if Section 8 can terminate a voucher or a landlord can terminate a voucher if a tenant gets a felony DUI and it's the first offense and there's no criminal record. Hi, my name is Rob Wells. I'm the landlord. We're on TikTok and YouTube. Please feel free to like, share, subscribe to our videos. Now, let me answer the question from the framework of, can a California landlord terminate a tenancy for just cause if a tenant gets a DUI felony? Okay. I'm going to say it's going to factually depend on what happened. Okay. Because, for example, if the tenant got a DUI felony, like on the middle of the freeway, Highway 80 or something, way away from the rental property, I'm going to say no, it has no bearings on, hey, tenant got pulled over by, I guess let's call it highway patrol or whatever, and they got pulled in for a felony DUI. Okay, that has no relation to the property. Okay, turn the facts around a little bit. Tenant, is way over the legal limits, for, drinking or whatever, smashes into like a carport and then runs into another tenant's unit. Okay, then they get jammed for DUI felony. Okay, if that's the case, I think in California, at least, the landlord would probably have a strong case for a 3-day notice to quit for nuisance or using the property for an unlawful purpose. The tenant engaged in criminal conduct that, doesn't warrant, like a warning, basically. Okay, because most lease violations are curable or incurable. Tenant smashing in to like a carport, destroying, other property, injuring other tenants and residents as part of that felony. I think landlord could probably terminate on a 3-day notice to quit. Okay. Obviously the facts are going to these situations are highly factual. Landlords would want to consult with counsel just to make sure, hey, everything's on the up and up. What evidence that the landlord, has to prove that violation. If you start getting into property damage on site and or injuring other residents, that type of deal, I'm moving towards the 3-day to quit. Okay. But if it's like a DUI, outside the vicinity of the premises, it has nothing to relate to the landlord's property or other residences or neighbors in that area, I don't think you're going to be able to evict someone. That being said, this questioner was asking about, like, I guess, could a tenant lose their Section 8 voucher? Okay. There are some provisions, I guess, in the federal code about if a tenant engages in criminal activity that threatens the health, safety, or rights of peaceful enjoyment of the premises by other residents or by people living in the immediate vicinity. So if you got a situation like I was just talking about, like, hey, this tenant caused massive property damage, injured individuals, I think probably that the housing authority might be able to terminate the voucher. I don't deal with how the local housing authority terminates a tenancy voucher. Basically, I'm more for the landlord, if you can terminate for cause. So that's going to probably vary, but I think if there is some significant harm, disturbance, that type of deal, I think probably the housing authority might have grounds to terminate that voucher permanently. So, but that's beyond the purview of my expertise in this video here. So folks, landlords, if you have questions about, if you have that type of situation occur or any type of criminal activity and you're in the Northern California area, feel free to reach out. We might be able to help you out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.